And let me just hide this. Okay, so good morning. Happy May 22nd. So happy Friday. All right, we're going to dive into today's lecture about the cancellation of contract and disposition of deposit, and also the cancellation of escrow. So today's lecture is going to be a better understanding of how the car form CC is utilized and how to avoid liability, protect the deposit, and then obviously navigate real life situations that can happen when you are involved in a real estate transaction, when you're in escrow. It doesn't matter who you represent, if it's the buyer or the seller. There's going to be a time in your career where unfortunately the deal will have to cancel. The deal will have to cancel, right? It's knowing how to navigate who is initiating the cancellation. And it's a two-part process, right? It's asking who is initiating the cancellation, and then what happens to the earnest deposit. Does it go to the buyer? Does it go to the seller? So we're going to dive into it and get a better perspective and an understanding, because it is sometimes a risky business. I'm dealing with several cancellations right now, and there's a dispute. I'll share the story after the presentation. I want to dive deep into this just so that way we're in and out of the class on time. So part of the process is an understanding that the buyer and the seller have to initiate the cancellation if it's reasonable, right? And again, it's based on the buyer's position. Maybe the buyer decides that this property is not the right home for them, and after they have done their due diligence, they just feel that this property is not the right property. So it gives you the right to exercise the cancellation, and more so the ability for you to um, instruct escrow on what the next steps are, and ultimately release the earnest deposit back to the buyer. Okay, there we go. So who here believes if a buyer cancels escrow, the deposit automatically goes back to the buyer? Okay, so wrong. Okay, escrow cannot simply release the funds because one party is demanding, right? So if I'm a buyer's agent and I submit a cancellation from my buyer, it doesn't necessarily mean it's canceled, right? It has to be mutually agreed upon by all parties, right? The cancellation of contract, the cancellation instructions, the deposit deposition, what happens to the money? Does it go to the buyer? Does it go to the seller? Because the buyer may be in the wrong, and the seller may challenge the cancellation, says, look, we'll cancel, but that money is a breach of the buyer's duty, and therefore the buyer's deposit shall be to the seller. Okay. So I want you to understand the distinguishes. It has to be one and foremost mutually agreed upon before escrow will release any money, because that's a big risk. We're talking literally thousands of dollars that are being held through escrow. So understanding the elements and how that works will justify who's entitled to the deposit. Is it the buyer or is it the seller? What you're going to learn today is by the end of the class, you should have a better understanding when cancellation right exists, the differences between one party versus mutual cancellation, understanding the release of the deposit, identifying broker liability traps, understanding when escrow can not release funds, and obviously navigating disputes professionally. And the funny thing is, I deal with these on a regular basis. That not that is good or bad, it's interesting in my opinion, because there's so much emotional attachment to a cancellation, sometimes it can go easily left field, right? Now, when it's proper to do a cancellation, it should be good. Professional real estate agents should navigate and ultimately release the party from the obligation to continue, right? But it's when there's a dispute, that's when it gets a little bit more complicated. Okay. So, why this form matters, right? Well, one is the cancellation of contract. Okay. Then part two talks about the deposition of the deposit. Number three, it talks about the cancellation of escrow instructions. So cancellation and release of funds are separate issues, okay? It's not tied into one. It's separate issues when it comes to a cancellation, right? And I'm going to share some stories on a cancellation that we still have a dispute. Then we're going to have a cancellation of a canceled escrow, but ultimately we ended up opening escrow with another party, and that money is still tied into escrow and nothing has been done, right? So there's distinguishes in how you navigate the cancellation. All right, so the form CC, page one talks about the contract cancellation, right? That's the first page of the form. Part two goes into the instructions of the deposit. It also says about partial release. Who is entitled to that partial release? Is it the buyer? Is it the seller? Reservation of rights. Okay. What are the reserves rights to the deposit? Because there's someone that is challenging it or is asking for it, right? And that's a reservation of rights. And then obviously to execute an agreement, it must be signed by all parties, right? Because I can represent the buyer, right? Have the buyer sign, send it to the listing agent. Listing agent passes it to the seller. Seller says, nope, I'm not signing that cancellation. And then I get that cancellation, send it to escrow. And then I say, escrow, please cancel this agreement and release my deposit. Is escrow able to release that earnest deposit when you don't have the seller's signature? The answer is no, because there's not a mutual agreement. Okay. The only time that it becomes an executed agreement is when they agree to sign the form. Okay. It may be an agreement that the seller is fine to release that deposit back to the buyer, or they may be standing their ground and saying, no, I have a dispute. I did all of these requests of repairs. We wasted 60 days and the buyer now is deciding to cancel. We'll cancel, but there's been damages here. I want to go after some, if not all, of the deposit that is in escrow. So again, it's how you navigate these conversations to get it to the finish line. Our goal as real estate professionals, right, is to really help diffuse the situation, de-escalate, and ultimately do what's right. Now, how many times have we been in a conversation where the buyer is a first-time home buyer and we're explaining to the buyer the initial process, and once your offer gets accepted and we open escrow, they ask you, so what if I decide to cancel? Do I get my money back? Okay. That's a common question that comes quite often. And how do you answer that question? Is it a yes? Is it I don't know? Does it depend, right?
Two-word answer.
Yeah, absolutely. It really depends on where we're at with the process. Because if you say to the buyer, yes, you'll get your money back, and the seller says, no, 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 I have a dispute regarding this, now it's going to look bad on you that you guided that buyer and gave some type of legal remedy or advice regarding their deposit. Remember, deposits can be up to 3% of the actual purchase price. Yeah. Again, if it's a $1 million deal, 3% is $30,000 that's tied in escrow, right? Or as Steve says, it can be even more, right? So you got to be able to navigate this because it is a very fine line. And when the emotions come in, that's where it gets very intense and very stressful, right? So our job is to navigate, but ultimately it is the buyer and the seller's discretion and decision how they want to navigate this approach. Broker liability and warning. Okay. Agents are not qualified to determine who is entitled to the deposit fund. We're not. Okay. I cannot tell you, even as a broker, I cannot tell you that I am saying to you that you're going to get the deposit. Even if I represent the seller, I still can't say, well, based on this information, I think you have a very good chance of getting the deposit. The answer is we don't know. Okay. The way you neutralize that conversation is very simple, right? You throw it back at them. It's your discretion. I cannot give you any guidance of what can happen to that deposit, right? Based on the information here, right? I would honestly ask you to speak with an attorney. And I did that yesterday. I really did that yesterday. We have a dual agency situation. I have two agents, the same office. One represents the buyer, one represents the seller. The seller listing agent is a family member. So the listing agent and the seller are related. The buyer is working with one of our other agents. Well, the buyer did their due diligence and ultimately got their inspections done. And part of the home inspections, it says that there was some issues with the plumbing. So, on the request of the buyer asked the buyer's agent, "I'd like to see if we can do a what do they call it? A hydrojet on the plumbing." He got the permission from the listing agent to do so, so they went ahead and did a hydrojet of the plumbing.
At the expense of the buyer.
Of the expense of the buyer, yes. So the buyer then, within days after, decided to cancel. And well, I take it back. The buyer did not. The buyer received a notice to perform because the buyer wasn't releasing that contingency, and then the listing agent sent a notice to perform. Okay, they've done the hydrojet already. And then all of a sudden, the cancellation was sent to the buyer's agent because the buyer did not perform due to the notice to perform of releasing the physical inspection, right? Um, the buyer, yes, because they didn't release it. Buyer says to the buyer's agent, I don't like this cancellation. I want to send my cancellation and ask the buyer's agent to send their interpretation of the cancellation. Because the cancellation that the listing agent sent was due to the non-performance of the buyer, which the seller had the right to do so because the buyer didn't perform to release that condition. Okay. So between that time when they received the seller's cancellation, within 2 days, they sent the buyer's cancellation on the instruction of the buyer. In between that time, the seller got notification from the neighbor, it's a condo, that there was some leaks. After further inspections, they realized that it probably was done with the plumber that did the hydrojet. So now the seller says, I've been damaged. Because the buyer did the hydrojet, and now we sustain a bill of like $2,500. I'm not going to I'm not going to cancel on the buyer until we get some compensation. Now the deposit is about $25,000. So the listing agent draft a new cancellation, says we'll go ahead and cancel, but we're asking part of that deposit to be given to the seller for damages. The buyer says, wait, wait, wait. It's not my fault. It's not my due. What proof do you have that the company did that damage, right? Well, the seller says, well, it's ironic that after the hydrojet was done, within a day or so, it started leaking to the neighbors. Now it's I believe it's a condominium. One is on top of the other, and then that's where the leak and the plumbing started happening. So that's their conclusion of why they feel we didn't have this problem. We've owned this property for years, and we've never had any issues. Out of curiosity, the hydrojet was performed, and within a day or so, now we have water leaks.
How would the buyer do work to the property before they own it?
Very good question.
That's in it before.
Why? Exactly. Why?
That was the first mistake.
I don't know why. It's no difference than when a request for termite, right? And part of the condition is to get the termite completion, right? So they'll do the completion. What if the termite company does damage to the property? Who's responsible for something like that, right?
So within the contract, the buyer indemnifies the seller for any work.
That's right.
Inspections that take place.
Right.
Ultimately, then whoever performed that service ultimately then is responsible back to the buyer, as well. So
correct. Well, I'm getting to the conclusion because it's a very interesting situation. So when the buyer reached out to the plumber takes some responsibility, but doesn't take all responsibility, says it could have happened. I'm not disagreeing, but I was given authorization to do an inspection. And part of his agreement, there is limited liability that is done when he does this type of service. Because, if you know what a hydrojet, it is full force pressure cleaning out the pipes, right? And if the plumbing was already in bad condition, it's just going to make it worse. And that's probably what happened. It just ended up making it worse. It was bound to happen. It just had to happen, right? So the plumbing company is not taking responsibility, but they're also not saying that, where's the proof? Okay. Because when we did the inspection, we also videotape. We have images. There was no leaks after the service was done, and they ran the water and all that stuff. So we don't know if it was done by the termite. So this is again the back and forth, right? What proof? Okay, it's not like you had a camera while the hydrojet is pressurizing the plumbing, and then you see where the issue is, right? So I can see from a buyer's point of view and also from a seller's point of view, it's kind of a balanced situation, right? So the buyer's disputing this situation says, no, I am not to be blamed because of this situation. And I am not going to pay. I am asking the listing agent and the seller to release my full deposit back to me so I can move on. Well, the listing agent and the seller says, no, I don't think so. We're bound now. You canceled. We did this work on your behalf. And now you're deciding to cancel, right? Which again, the buyer is within their right to do so. If they didn't release the contingencies, it's one of those situations. Now, just because the buyer is in the right doesn't necessarily mean that the buyer is right. It doesn't mean that the seller cannot challenge, the situation and say, we've been damaged, right? It depends on the circumstances. Now, a seller cannot just hold the money hostage because they're pissed. Let me make sure I'm clear with that, right? A buyer's deposit is in there for good faith to basically say, we want to buy this property, okay, with the intent to close it. And I know we're tying up the property for a minimum of 30 days. So I'm going to put some skin in the game by putting an earnest deposit, okay? I would be foolish if I'm a listing agent receiving an offer with no deposit in escrow, right? Because you just never know if any circumstances like this or even something even worse may happen. So because it's a dual agency transaction, two different agents, same company. Both agents reach out to the broker and ask, "Hey, we have a situation here. We need some guidance and kind of an understanding of what the next steps are." So I says, "Not a problem. Let me analyze both sides of the story, and both are legitimate, right? Both are legitimate. And here's my problem as a broker, right? I cannot side for any of them. I have to be very neutral in my position because it's one of my agents. It's one of my agents. So I'm not going to say, "Oh, you're right. Let's." No, I cannot do that, right? I have to keep it very neutral, right? So I listened to both sides of the story and the compelling position. And I said, the only thing is get your clients instructions of what they want to do and let them iron it out, right? Put yourself out of the equation. Let them try to figure it out. Now, part of the contract, it does have, a due process when it comes to, if there's a dispute, you must mediate. If there's a dispute, you can also arbitrate, right? So I says, the other avenue that we can approach it, if there's not a meeting of the minds between the two parties, then why don't you exercise the mediation process and get a mediator to do this? And hopefully we can come to an agreement. And so they were tossing and turning, and they're just holding firm. This cancellation should have canceled early in May. I think May 4th is where the buyer sent the cancellation. We're what, the 22nd? The 20? Yeah.
Question.
Yes.
Was that repair done? The plumbing, the $2,500?
Yeah, it was done.
A different plumbing company then, most likely.
Correct. Yeah. So
It's a shame because almost the best remedy could have been had the company who is involved on this, had they almost should have been the company to done the repair at their cost and just
I agree.
done out of it. That could have been and should have been the best remedy to remedy this thing.
Well, and again, the plumbing company is not taking responsibility. Also, not saying that they say it could have happened with the machinery, but they also says, well, where's the proof?
Yeah.
Exactly. So this should have been canceled early in the month, and it didn't. And now we were kind of on a standby, and it was quiet. I didn't hear anything, and all of a sudden, 2 days ago, I get a crazy email from the buyer. And now the buyer's threatened that if you don't release, you, broker, are responsible. This is a due agency. And if you don't release my money, then I'm going to go after you and file complaint with the Department of Real Estate. So, and everyone was CC'd, the listing agent. Now, what's so complex of the situation is there's the listing agent who is the mentor, and there's the agent who is the mentee representing the seller, and then the buyer is represented by the agent. So there's three agents involved, all within the same office. So the email came in from the buyer, and everyone was included: the buyer, the seller, the listing, excuse me, not the seller, the listing agents, the buyer's agent, and escrow was all included, including myself. And the email was directed to me as the broker, saying, "You're responsible, get this done and get this fixed." So immediately the listing agent calls me, and immediately the buyer's agent is like, "Oh my gosh, I'm so sorry, Simon," because it's a very nasty email and I get it. The buyer's pissed. $25,000, 3 weeks, 4 weeks later hasn't been released. I would be upset too as well. So they gave me their perspectives again and just kind of give me up to speed. And I says, okay, the only thing that I'm going to do is I'm going to call the buyer. I want to hear the buyer's side. So yesterday afternoon, I literally for about 20, 30 minutes, I was on the call with the buyer, listening to her position on why she feels that the money should be returned back to the buyer. And I let her vent. I just let her spill everything, right? And after she exhausted every avenue why she feels that the deposit should be returned fully, I says, well, thank you so much for sharing your position, right? I'm going to give you some options here, okay? Now, option one is we can try to mediate this. And by mediating this situation is, look, not that you're taking responsibility, but obviously there's a dispute. The seller is not going to sign off on the cancellation. So therefore, are you willing to maybe possibly throw some money into this situation? Okay. Well, what do you mean by that, Simon? Well, again, it's not going to be any different than in front of a mediator. The mediator is going to do the same thing. The mediator is going to hear your side, the other side, and then they're going to try to resolve this by negotiating something. I'm not saying to pay the $2,500, but give me something to work that I can now propose to the listing agent so they can relay that to the seller and see if we can be done. I rather release 95% of your money, or you're going to be stubborn and still hold this money because the seller disagrees. I said the next process would be is to obviously speak with an attorney. I encourage you, because you started saying, well, if you don't take care of this, I'm gonna get my attorney involved. I says, do it. I encourage you, please speak with your attorney. Okay. We haven't done anything wrong. This is not a dispute between me. She's upset. I get it, but I didn't do anything wrong. And here's the problem with a lot of agents. They get so emotionally entangled and they feel like they're in trouble. And that's why sometimes you do and say something that will compromise your position. You hold your composure. Let them do whatever they want. So I says, I would encourage you to speak with the attorney. But guess what? That's going to cost you money. You hire an attorney, you're going to pay a retaining fee. $25,000, $5,000. They charge anywhere from $200 to $500 per hour. Okay. So if you think that you want to go in that direction, by all means, I would encourage you. One way or another, there's going to be money here, either through a mediation process, hiring an attorney. So I am trying to do this at no cost to you as the broker, where I'm not asking for compensation. I want to release this money to you, but I have no authority to do so. It's not my decision, nor my agent's decision. It is the seller's discretion. And because there's a dispute, read the contract. Paragraph 29 talks about a mediation process when there is a dispute. Okay. Then I step out and you guys iron it out. Option one, speak with an attorney. Option two, go through the mediation process. Here's the website that you can hire a mediator to do this. One or the other, it's going to cost you. And still no guarantee that you're going to get your full deposit. Now, in addition to a mediation fee or an attorney fee, you may still lose some of that deposit. I don't know. So I asked her, do the right thing and speak with an attorney and then advise. Then she says, well, send me an email of what all of this so I have it in writing. So last night I compiled my email and I hit all of the bullet points. I included everyone on that email. So full transparency that I've done my role and my responsibility to try to diffuse the situation. And it's up to her now. Whatever direction she wants. Hire an attorney, have the attorney speak with me. I talk to attorneys all the time. I love talking to attorneys. I'm talking to one yesterday. that was also difficult attorney, but I, was able to diffuse the situation and get it resolved. Attorneys don't scare us. Okay. It's just the initial process. And the reason it doesn't put fear in me is because I understand the contracts really well. And I have confidence in the contracts very well. Just like Steve here, he understands the contracts. So there's not that fear factor when it comes to communicating with attorneys. Now remember, and I want to be crystal clear, I am not an attorney. I don't claim to be an attorney, but I understand the contracts and how they work and function. When there's a dispute, we step out, let them duke it out and fight it out and come to a resolution. We're here just to guide and give some type of parameter to get them to the finish line. And that's exactly. We're just problem solvers, right? But our goal is to get it to the finish line, right? So she has not responded back. We're still waiting. We'll see what the decision is. I told her, look, I'm not telling you what amount, but just give me something. If it's $5, give me $5. I'll bat for you to see if we can release the money, right? Because again, I see both sides. Why would the buyer be responsible when the buyer doesn't live in the property? The seller still owns the property. I'm thinking out loud in my head, not that I said that to her, but I says, go 50-50. If it's 2,500, what's half of 2,500? 1,250. Yeah. So just
go away.
Yeah.
Or you want to move on with your life.
That's right. I think that's that, and I'm thinking in the back of my mind, I think it's reasonable. Look, the seller puts in, it's their house. They're going to sell the property one way or another. It's still going to need repairs. So they benefit from it. Go with that motion and go 50%, right?
Was there even dialogue for the seller to release the balance of the funds other than the disputed amount?
Well, that's all they're disputing is.
No, I mean, if there was if the deposit was $20,000 and we're talking 2,500 part that's in dispute, for the seller to release the 17,500 back to the buyer and just retain the 2,500 that's still in dispute, still until that portion gets resolved. So at least the buyer, receives back the majority of the deposit funds, the part that's not being disputed.
Yeah, I like how you think, Steve. No, I don't think we explore that option because again, the buyer is adamant that she is taking responsibility. So she wants, and she made it very clear to me yesterday, I want all of my money. All. So even if I was to go in that direction, she would have probably declined that scenario. So I don't know. We'll find out. And if she doesn't do anything, well, the seller is in no hurry. The money's still going to stay in escrow, unfortunately. So, but going back to broker liability and warning, agents are not qualified to determine who is entitled to deposit funds. Facilitators, not a judge, not an attorney, right? It's just buyer and seller at the end of the day. They're the ones that say, look, all right, you know what? I am done with this. I want my deposit back. Here is $1,000, take it. Okay. And then I throw it back at the seller. Hey, look, in good faith, the buyer, not that they're taking blame or fault to this, but they're offering $1,000. I would encourage you, and again, it's your decision, but I would encourage you to take it and run. Okay. And then once that's done, we instruct escrow, which Sparkle here is with us, from upstairs Pacific Coast escrow, and she can give you her perspective as well when it comes to mutual agreement, right? Not that it's blaming the buyer nor the seller. It's just sometimes these situations happen. All right, so advisory language and key concepts, right? Act in good faith, right? All parties must act honestly, fairly, cooperate throughout the cancellation process. Sometimes emotional comes in, and sometimes there's no rational of the reason. Sometimes you gotta let them vent, right? Let them just spill everything and then angle yourself, because like Steve was saying earlier, right? We are problem solvers. We're engineers. We have to think different. We have to be 2 steps ahead of the circumstances. What if this happens? How do we handle it from here? So it's our job to maneuver this in the best practical way, right? Because I know it's a lot of money. Damage may exceed deposit. Again, I would caution you. Look, if you're a listing agent and the buyer hasn't released all contingencies, I wouldn't do any request of repair that was already approved or accepted by the seller until I know that the buyer has released all contingencies, because now I have every right to go after the full deposit for damages. Now I can claim, well, I did the termite, I replaced the window, I did the plumbing, and there's a $35,000 deposit. My expenses were, $22,000. So the seller can go after the amount that they were damaged, or per the contract, go up to 3% if the buyer is buying the property for as a primary residence as well. So keep that in mind. Disputes may require legal advice, right? So when disagreements arise, independent legal counsel may be necessary, right? So again, not that we're referees, bring us into the picture, right? Leadership. If something just feels that it's going sideways and it goes sideways really quick, bring me into the picture, right? If I am your broker. If I'm not your broker, then go to your broker or your team leader and have them help and navigate that situation. We're all here to support and help, but at the end, we always recommend that the agent let their clients know, please, maybe it's time to speak with an attorney. I'm dealing with another cancellation with one of our agents here as well, where now the buyer ended up getting an attorney, which is good, which I recommend it because we represent the buyer. And I did my very best, and I thought we had it where we were moving forward. And then they threw a wrench and says, no, the seller changed their mind. They want to cancel. And the reason the seller wants to cancel because they don't trust the buyer, that the buyer is going to still come back and sue us. Well, if you understand the story behind the situation, the seller wasn't fully transparent. This was a condominium. She refused to give the updated HOA documentations, the CCNRs, the bylaws, the financials. And then after the buyer requested directly through the HOA, and there was all kinds of things that were being hid by the seller. So it ultimately opened up a can of worm of new material fact, and they were just asking for additional things to be done. And then the seller says, nope, we're not going to do it. After all of this, the seller wanted to cancel. So I stepped in, and for about 2.5 weeks, back and forth, I thought we ultimately got the seller to agree and move forward. What she agreed, and it was the termite, and then the seller rescinded that after acceptance. So there was just a lot of things, and I think it's a little bit of a culture too as well. The seller is Chinese, and I don't think that the agents were really representing, and these were two agents, experienced agents, that were representing the seller, and we were representing the buyer. But it was a hot mess, really hot mess. So now I just saw an email yesterday that the buyer's attorney representing the buyer sent out an aggressive email to the listing agent, and to make sure that the seller is doing the right thing. Parties not agents, exercise cancellation rights. Only the parties to the agreement, and I want to be clear with this, we are not the ones that are making the decision of cancellation, folks, okay? It is under the discretion and direction of your clients of what they want. They may be wrong, but if they're telling you, I want to cancel, then your job is to do the contract and cancel. That's the instructions. Because if you don't, then they're going to say, well, you don't have my best interests. Okay. And that can happen too. And that's another can of worms. How many agents become emotionally involved and start deciding who is right, right? Don't put yourself in that situation, right? Because if you do, and it doesn't go the way it should go, they're going to blame someone. They're going to blame Salvador. Salvador, it's all your fault, my friend. Okay, you told me I was going to get my $45,000, and now the seller is pissed, and now is not even giving me my money back because they're not signing off on the cancellation. You told me. So I'm now going to go after you as well for misrepresentation. True story, guys. Okay. I am not sugarcoating this. Okay. Not here to put any fear in anyone. Okay. I don't want you to be in fear of it, but I also want you to be, um, what's the word I was going to use? Uh, Gosh, I just had it and it just lost me. But just be cognizant. Thank you. It started with the C. I just couldn't put the word together. Cognizance of the situation, because when you are in the forefront and thinking two steps, then you'll know how to navigate the conversation. Yes, sir.
One of the things, especially when a transaction is starting to go south, and especially when you're now talking to your client and then talking to the other agent, one of the best ways to be able to help diffuse the situation somewhat is to eliminate the word we when you're talking about your client. Okay. It's my client. I've advised my client said this. It's not, we're canceling escrow. Okay. We think we're not being treated right. We think, because if you use we, even though you're trying to use the best, you're trying to stand up for your client, you're emotionally charging the situation by using the word we is what I have found.
That's right.
Anytime that, the description is my client said this, the seller said that, my buyer said this.
Right.
Okay, or my buyer wants that.
Right.
Okay. It's my buyers, not us, not we. Okay. And that really, really helps diffuse, which even goes to negotiations as well. Okay. I'll bring that up to my client and see what they say. As opposed to we don't like that.
Yeah.
My client doesn't like that.
That's right. Yeah. Good point. All right. Section 1A on the cancellation of contract. It says the one party cancellation. One party may initiate the cancellation when contractual right exists, right? And again, just going through the motions of it. If I represent the buyer and we go through our due diligence and we know that the default is 17 days to release that condition, and the buyer within 10 days says, after really looking at the property, yeah, I just don't think this is the right home. I want to cancel. Okay. Now, our job is to kind of get to the core of what the reason behind it, because it may be a small fix that we can ask the seller to fix it, right? What is it about the property that you don't like, or what is it that I can help before you decide to cancel, right? Well, it just doesn't have an AC and I really truly want an AC. Wow, that's a big ask, right? Well, again, there's so many things that can transpire on the buyer's decision to cancel, which is fine. And if it's within their right to do so, then yeah, it's easy. Then we can use paragraph 14B as an avenue to exercise the buyer's reason behind the cancellation during their due diligence period, right? And because of that, the buyer has all of their contingencies in place, then the seller and the listing agent have no choice but to cancel. You can't force a buyer, and just because you're pissed off, you can't even do a specific performance. Well, I want to, and I've heard that in the past. I want to have the buyer and force the buyer for specific performance, right? You go, well, I don't. Again, I'm not an attorney, and I'm not saying or guiding you. I would obviously have you speak with an attorney, but I don't think you're in that position right this minute to do a specific performance on the buyer. The buyer has their due diligence periods, to release inspections, seller disclosures, appraisal, loan contingencies. I can understand if the buyer on the 29th day after releasing all contingencies decides to cancel, then you have every right on top of, possibly damages and, the earnest deposit. But until that time, the buyer has every right to cancel. So if you get a question that says from the buyer, hey, if I do get my offer acceptance and I don't like the property, or there's too many issues with the home, Can I cancel, right? And then the answer should be, it really depends on where we're at in the stage, right? You're not going to say, oh, yeah, yeah, yeah. But then that, yeah, you're 30 days in, the buyer has released contingencies, and now you're in a situation. I'm dealing with another situation in the Valley with another agent who represents the buyer, submitted an offer, and the lender has been dragging their feet. They're going now almost 50 days. And as for the seller and the listing agent, are upset. They've been threatened to cancel, but they've been giving them the extension. The buyer has already released half of the deposit to the seller. And now we're still uncertain. They're saying next week we should be able to close. And it's like, I'm in the middle of a chaos. The buyer's agent is just kind of lost in this, and it's relying on the lender. The lender, thank goodness, he's in communications with us. But I have to now, and I got the permission from the listing agent, who we don't represent, the seller, the listing agent, for me to speak with the seller. Okay. Very far and few, but I was able to convince the listing agent to give me an opportunity to speak with the sellers, to just give them our side of the story. And usually when that happens, then I can try to defuse the situation, and because they're ready to send that demand to close. And if they go for the demand to close, the buyer's losing all of their deposit. And they already released half of it already. So it's just sometimes you have to take some risk, right? That's why you have earnest deposits in escrow, for that purpose, right? Again, it's not our decision to say to the buyer, do this, 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 this. It's the buyer. Hey, you're the one that's buying this property. I'm just giving you what the contract says. And, it's up to you what you want me to do.
Did the buyer release all contingencies?
Yeah.
Non-contingencies?
Yeah.
You can know it.
Wow. Everything. Because the buyer really wants the property, and the lender keeps promising.
On the lender.
Yeah, the lender keeps promising we can make it happen. There were some conditions that the underwriter came back, but it's something that I fixed. So it's just this back and forth. All right, one party may initiate the cancellation when contractually the rights exist, right? Contingencies have not been removed. Notice to perform issued. The demand to close. Now, in that circumstances, look, the demand to close, it's a two-way part, right? If you still have your contingencies in place, if you've held on to them all the way to a demand to close, then you must have done something right as a buyer's agent to hold the contingencies in place, right? But usually by this time, when a demand to close, it's most likely that the buyer has released any and all contingencies, right? And the demand is the actual date that it's scheduled to close escrow and did not close. The seller says, look, I'm giving you one last opportunity. You got 72 hours to perform. And if you don't perform, then unfortunately we have the right to cancel and go after the earnest deposit. Okay. Yes, sir.
Is any cancellation bilateral?
Any cancellation bilateral? What do you mean?
Require both seller and buyer signature?
Oh, yeah.
Yeah. So to answer your question, yes. Just because I send the cancellation with the buyer's signature, escrow will not release the deposit. It has to be signed by all parties, the buyer and the seller. Agents have nothing to do with just the buyer and the seller. The agents are out of the equation. Agents have nothing, no authority regarding the deposit. That's correct.
Or paper pushers.
Yeah. And then last, failure of the contractual obligations, right? If, again, these are some of the scenarios where a single cancellation that grants the buyer's ability to retain their full deposit is if they didn't release a contingency, a notice to perform was sent because they didn't release the contingency, a demand to close if they didn't release a contingencies, and then the failure of contractual obligations, putting the earnest deposit, not returning seller disclosures, not getting the appraisal, stuff of that nature, then the buyer has the right to cancel. Having the right to cancel is not the same as resolving a dispute. There's two distinguishes, okay? Cancellation or a dispute. If there's a dispute, now the situation is agents step back, let them iron it out, buyer and seller. All right, so the cancellation doesn't mean contract is canceled, okay? Just because the buyer is within their rights, it doesn't mean by sending a cancellation to the listing agent and to escrow that is canceled, right? Deposit, it doesn't mean that the deposit will be released. So I want to make sure that all of us are clear, which a lot of us understand already, but it has to be, again, mutually agreed. Escrow is in close and dispute is in one, right? Just because the buyer has a compelling position or the seller doesn't mean that they won the situation. It has to be agreed upon, right? For what the situation is. A one party cancellation creates a position, it does not resolve a dispute. Okay. Just because the buyer is within the right to cancel, which is good, we're going to send the paperwork to the parties that need to get the cancellation, but we're kind of still in the mercy of the listing agent and the seller and escrow to do their part to release the funds and to cancel as well. You want to get that receipt saying that the seller has mutually agreed to cancel. The 5 reasons under Section 1A, okay? 1, good faith contractual rights, right? Example, the contract express allows steps under these conditions. Buyer fails after the notice to buyer to perform. Buyer missed the new business period, deadlines, or failed to act. Seller fails after the notice to seller to perform. Guess what? Both have responsibilities. It's not just a one-sided agreement. The buyer can also ask the seller, hey, you haven't performed on your obligations. I am now sending you the demand to close, the demand to perform. And if you don't perform, me as a buyer have the right to cancel. Now, what are some of the things that a buyer can do to the seller for a notice to seller to perform?
You mean for what issues?
Yes, for what issues?
Seller to perform.
The buyer sending a seller a notice to seller to perform. What are some of the reasons that a buyer can send a notice to seller to perform? Because the seller's not performing.
Request agreement. Lack of agreement on request agreement.
Okay, what else?
Seller not sending disclosures.
Yeah, bingo. Seller hasn't sent any of the seller disclosures. I don't have a TDS, SBQ. We don't know how the condition of the property is, right? And then if we don't receive them in a timely manner, then the buyer can send a seller to perform, saying, hey, we haven't received seller disclosures. I'm sending you the seller notice to seller to perform. You have 48 hours to perform. Otherwise, the buyer will back out of the deal. Okay, that's right. Number 4, failure after a DCE, right? Again, if the buyer has performed and the seller has been MIA, and we're scheduled to close today, and we haven't been able to close, then the buyer has every right to send the seller a demand to close escrow, and if they don't, the buyer has every right, even after releasing all contingencies. If the buyer sends a demand to close to the seller and the seller doesn't perform within 72 hours, the buyer has the right to cancel and the buyer has every right to get their full deposit back, okay, per the contract. All right, scenario, active contingency cancellations. Buyer holds an inspection contingency, buyer cancels on day 14. No contingency has been signed. Can a buyer cancel? Likely, yes, if the contingency remains active. Okay, remember, contingencies are like walls. This is the buyer's deposit. There's walls and shields that protect that deposit. Every time a buyer releases a contingency, the seller gets closer and closer and closer. Once the buyer releases all of the walls and all of the contingencies, now it exposes the buyer's deposit. If the buyer fails to perform or doesn't close the deal, the seller feels damaged. The seller now has rightful to the earnest deposit. That's simple. Think of it that way. A shield protecting that deposit. Every shield that is released by the buyer brings the seller closer to activate that deposit if the buyer fails to perform, decides to cancel, cannot get the loan, there's a dispute regarding the appraisal, and the buyer has released the appraisal. That's still not a good reason for the buyer to back out of the deal because they can't get the loan, but you release the appraisal, the seller may still feel damaged. Okay. So just keep that in mind. Scenario number 2, cold fee after contingency remove. Buyer removes all contingency. Buyer now has cold fee and wants out. Okay. Cancellation requested? Yes. Automatic deposit release? No. Right? So think about this. You're the buyer's agent. Buyer released all contingency in good faith that they want the property. And then all of a sudden, they got a shock of what their mortgage payment is going to be. I'm going to what? Pay that amount? No way. That's too much. I don't know how I'm going to pay. I want to cancel. All right. We'll send the cancellation. Okay. There's nothing you can do about it. You cancel, but there's no likelihood that the seller will agree to it without being damaged. If you're lucky, you can try. It's like playing poker, right? You can try and have that poker face and kind of see if the cancellation is signed by the seller, releasing the deposit back to the buyer after the buyer has released all contingencies. But the likelihood is, again, if I'm dealing with a Steve Gottlieb, he's probably going to tell and advise his sellers, hey, look, the buyer released all contingencies, we're so far into this situation, you've been damaged, in my opinion, right? So, okay, so we're not gonna mutually agree to. So we'll cancel, but that the deposit go to the seller.
But isn't it better to, if this is the case of, let's say, a loan situation, have the loan officer, communicate with both parties regarding the loan status constantly, rather than just wait after close?
It's not the escrow's job to communicate. That's the lender.
It's not the escrow. The loan officer and not the escrow, the loan officer communicate with the agents.
Absolutely.
They should be.
Yeah.
Good loan officer
Yeah.
will be communicating to both the buyer, borrower, and the buyer's agent.
Yeah, that's right.
If you as the buyer's agent, if the loan rep isn't, it's your job now to go after him, to be able to go for him, to communicate with that individual, to say, where are we? What the payment have you been communicating with the borrower, my buyer?
That's right. Yeah. All right. Notice to perform, the NBP and the NSP. What does it stand for? Buyer and seller. All right. So the notice to buyer to perform timing issued when the seller fails to perform by the contractor deadline. Service requirements must be in writing and delivered as specified in the contract. Personal deliveries overnight or certified, obviously through emails, confirmation, day counting, right? Again, very important, very vital in this situation. Counting begins the day after the proper service, including all days, unless last day is in a weekend or holiday. Guess what? This weekend is a 3-day weekend, right? So, unfortunately, if anything falls on a weekend or a holiday, then it reverts to the next business or calendar day, right? So that would be Tuesday.
Today, okay, there's normally 2 days unless it falls on a Sunday or a holiday. Okay,
Mhm.
2 days would be, today is 0, Sunday would be 2, but Sunday is Sunday, okay?
It's a weekend.
It's a holiday. So the expiration of that notice now reverts to Tuesday.
That's right.
So it actually follows that 2 days now actually becomes 4 calendar days if a notice was being issued out today.
That's right. Yeah. Yeah. Broker risk, improper issuance or missed deadlines creates legal exposure. And the same thing for the notice to seller to perform, right? It's kind of the same thing. No difference in distinguishes between the buyer and the seller. It's still the same thing. Day counting errors are among the top agent mistakes in escrow disputes because they don't know calendar dates and how the performance. Now, on the purchase agreement, if you go to the very end of paragraph 30, it talks about definitions. And there's all of your answers, ladies and gentlemen. All of your answers are on the paragraph of the purchase agreement. If you learn anything from today's class, go to the RPA, the purchase agreement, and go to definitions and study that. Because a lot of the confusion and issues and errors from agents is they don't know what they don't know. And I always revert, go to this paragraph in the definition, there's your answer. It makes you look like a hero. Okay. Makes you look like a hero. Yes, sir.
With another agent in the situation that 17 days it was given for the local contingency removal, and it's ended this Sunday, so it's going to fall to the effect of the following this day.
Yeah, and because it's Monday, it's a holiday, then it reverts to the next day, which is
It's calendar days, just so it's not business day, it's calendar day. Okay, the only business day timeline on our contracts is dealing with office one industrial.
Mhm. Good question. All right, demand to close escrow, DCE. All right, so you never want to see this one. Okay, but if you do, you got to put some pressure on the buyer or the seller. Agreement is executed, contingency removed, performance are done, performance do not occur, and then the day of escrow, we're still are not closing, then either party can send the demand to close. When it went to use it after all contingencies removed, performance not occurring, practical cautions, obviously proper notice, timing, and service matters. Failure to provide the DCE can ultimately forfeit legal remedies. Well, in a sense, yes and no. You want to make sure that you're doing everything and you have paper trail, because if attorneys are involved, the first thing they ask, give me the file. I want to see the entire file. So you want to look like you know what you're doing. Make sure that all of the documents from the summary of all of this transpire, because they want to see a chronicle order of everything that led us to the dispute, right? And as real estate professionals, our job is to make sure that we have all of the paperwork in place. This is why we ask all the time, hire a TC. Your TC should have all of the paperwork. You shouldn't be dealing with paperwork. Your job is communications and the process with your clients. Let the TC handle that. They get paid for that. They're better than us. I hate paperwork, and I deal with paperwork, but I just give it to the TC, and the TC handles everything. All right, proposed mutual cancellation. A proposed mutual cancellation is exactly that, a proposal. It is not an effective until both parties sign. It can be withdrawn. It expires after the third date unless modified. Agents must never tell clients the deal is canceled before all signatures are obtained and escrow is acknowledged. Everyone signs, escrow acknowledges, deposit address, right? Where does deposit go? Back to the buyer, back to or some to the seller, or all to the seller, right? So there has to be a mutual understanding and a mutual cancellation. The huge agent mistakes, the deal is canceled, all right? Never say that, the deal is canceled. No, it's not canceled until, I was going to say something funny, but I won't. Until everyone signs, right? Once we have the signature from everyone, that it's so funny because yesterday the seller, we represented the seller on a property up here in PV, and then the seller sends me a nasty email. I get emails, calls. I get some of the most problematic situations. I guess that's why I'm all white now. My hair is white, my beard is white, because I just deal with a lot of negativity, right? But you know what's so funny is I still hold my composure. You know what? I still sleep well at night, and I wake up ready for the battle, the good battle. So whatchamacallit, I lost my chain of thought now. So the seller sends me this nasty email and CCs her attorney. Okay. And I see that because it obviously says law or something on their email. And I've been dealing with this attorney anyway, so I knew it was. So I politely and professionally says, look, there's a disagreement. Our agent did not have the full time to sell your property because it was a 6 month listing. 3 months in, 6 months, 60 months in, she decided to cancel with our agent. So the listing agent says, look, I spent a lot of money. I hosted open houses. She didn't give me the time necessary. I want my expenses to be paid. $3,500. $3,500. So I sent the cancellation instructing the seller to sign it and paying $3,500 of expenses to the agent. And then I get then she calls blowing me up. Why hasn't this been canceled? It's already going to another agent, and the agent cannot put it on the market because you still have the listing on the MLS. I says, first, I never received the signed list of cancellation. And then she goes, oh, okay, let me send it over to you. She sends it to me, and she literally in red line crosses the $3,500. And then I look and I chuckle and I says, doesn't surprise me. This is the type of seller she is. And so I kept silent. And then she sends me another email. Why haven't you signed off on the cancellation? I says, one, you basically crossed that you will be paying after you had mentioned that you will pay the expenses that the agent incurred. And you redlined it saying, strike it out of this agreement. I'm not going to sign it. And then she says, well, I'll go ahead and agree to, but I'm not going to pay him now. I'll pay him on the successful closing of escrow with the new agent. I says, you think I'm stupid? That's going to be removed, by the way, from the class. Probably not. This is already like the fifth agent that she's canceled. We unfortunately are the fifth. Now she's going with the sixth, which was again the second agent. She just hired the same guy that she hired on the second time. So I says, what's to say that she's not going to cancel or this listing is going to expire? And because we allow that language, then she's not obligated to pay any marketing expenses that is due to the agent as part of the agreement. So I says, well, you need to change the language that way that it's universe that regardless if you close the deal, cancel or it expires, you're still going to pay the agent. So I says, give me the proper language, and then I do so. So the attorney sends this nice, pleasant email and says, is this what you want, Mr. Cazares? I says, yes, this is what. And then I told the agent, here's your proof. Okay. So then we ended up canceling. So yeah, people try to do some crazy stuff. If the answer to any of these is no, the matter still may be legally active. All right, so contract cancellation and fund release, right? That's again part of the contract. I would encourage all of you to really look at the form. It's a 2-page form. Get to understand the elements. Not that we want to be in a cancellation situation because we don't get paid, but also know how to navigate that and really articulate the conversation with the buyer or the seller, right? So moving to page 2 addresses what happens to the deposit funds, a complete separate legal question there, mutual instructions, arbitration award, or court order can happen if there is no agreement, then obviously it gets escalated, right? If we go through an arbitration, then ultimately whoever wins, that's your basic, like your court order saying, now we can give instructions to escrow saying, due to the arbitration and the winning, the money will go back to the buyer. The money will not go with the seller. And because we have that receipt, then that's the mutual agreement from the arbitration or a court order that now we can present to escrow, and escrow will now have the ability to release because that's a binding agreement that we went through the due diligence process through an arbitration or a court order. or a mutual instruction. Again, if I was to tell Sparkle we have the cancellation, the money going back to the buyer, we have the seller and the buyer signed, she's going to be able to release the money back because she's trying to protect herself too, because she doesn't want herself or the company to be in a liability. Why did you release the deposit to the buyer when the deposit should have been to the seller, right? That can happen. But once we have an agreement, that's her receipt, that's her proof that, this was the instructions that I was given. Okay, and that covers her. And that goes for a court order or an arbitration award. Yes or yes?
Yes.
Yes.
And
Yeah. All right. There's a section that talks about the Civil Code 1057.3, what agents must know. Refuse to release funds in a bad faith where no good faith dispute exists may result in penalties up to $1,000 plus in attorney fees.
Ridiculous. It's been $1,000 for the last 30, 40 years. I mean, that it should be more.
I agree. I would say 5,000 should be the norm. Wow. So, yeah, but that'll put a fire on someone. Okay, look.
Yeah. Again, it's for the purpose of no reasonable reason,
Yeah.
good faith dispute.
Well, I still think $1,000 is still a lot of money in my opinion. But you're right, Dave. Yeah, you're right. I think going up, and maybe that's something that we can definitely talk with CAR, right? I don't know, but again, the question here is no good faith. Okay, if the seller's just being pissed and stubborn and doesn't want to release the cancellation or sign the cancellation, then our position is, look, if you're in bad faith because you're pissed that the buyer is backing out and you feel that you're entitled when the buyer had all of their contingencies in place, not just are you
they jumped the gun on getting into a contract before their contingencies on the sale.
Right. Not just is that bad faith, but you may be penalized up to $1,000 plus if the buyer hires an attorney and the attorney was a $2,500 fee on top of the $1,000 and the 25. If the buyer wins, you as the seller is responsible to pay. When penalties apply, the agent unreasonably refuses to release the funds. Again, I see this happen quite often where agents are the ones kind of hostage in this. No, you can you can actually go after the agent too, because a lot of the time it's not the seller, it's not the buyer. Sometimes the agents are playing that mentality in trying to speak on behalf of the principals, right? Important protection in good faith dispute about the tenant's entitlement shields agents from penalties. Again, this is more of a situation where there might be a tenant in place and a disputed when it comes to cancellation of like cash for keys or something to that existence. Option C1, deposit to buyer. Deposit funds, buyer receives deposit funds, less applicable escrow fees and costs, possible reimbursement for inspections or reports. Again, there may be some responsibility that, in good faith, that the buyer's agent might be entitled to something as well, right? Not that it happens, and I wouldn't encourage it to do so, right? Because if you're still in good relationship with the buyer, and you're going to be representing them on the new property, you're going to get paid one way or the other, right? So the option requires mutual written instructions to escrow, not a unilateral demand. Under what circumstances might a seller agree to release funds to the buyer, right? So again, there's many reasons why sellers don't want to sign the cancellation. And sometimes there are good reasons for it, right? That's why we have this process. Deposit to seller, subject to liquidated damage clause, 3% purchase price limitation applies, owner occupancy and property type matters. Properties of 4 units or fewer, special rules apply. Seller cannot simply keep the deposit without meeting the legal and contractual requirements. Liquidated damage refreshers, initial clause require, property type governs, legal enforceability varies. Can a seller automatically keep the deposit? The answer is no. The liquidated damage clause must be separately initialed by both parties and properly conditioned must be met for it to apply. And that goes on the purchase agreement, right? And the reason is because if it's not signed and it's missing as part of your due diligence and negotiations, if you're working with the seller, you want to have that as part of the condition. Hey, the buyer failed to sign the mediation or the arbitration because it's a lot cheaper to go that route than hire attorneys. Split deposits. These are just kind of a scenario buyers. 12,500 remaining deposit, total deposit, 20,000, seller 7,000 from a deposit. Example, 20,000 total deposit, seller receives 7,000, buyer receives remaining 12,500. Negotiated settlements are often the most practical resolutions with both parties and collaborative claims. Again, when it comes to these situations, guys, remember, it's not that we're taking blame, just like the plumbing situation. We're just trying to minimize delays in attorneys. And this is why the mediation process works, right? As an example, this $20,000 is the earnest deposit that is the buyer's, right? But in order for this to come to an agreement, right, maybe the buyer did waste everyone's time, had the seller do all these repairs, and the seller has been damaged. And they can say, look, I've been damaged and I'm asking for 7,500. Then as long as escrow has the written mutual agreement in writing that instructs escrow to release 7,500 to the seller and 12,500 back to the buyer. As long as it's mutually agreed, it's perfectly fine. No deposit, what it means. When no deposit was collected or is an issue, the section still requires formal instructions to escrow. Well, again, these are situations, again, that can happen. When a purchase agreement is submitted and contingent counteroffers have been back and forth and an acceptance has happened, then the buyer and the seller now will be opening escrow, right? But what happens if that buyer does not put the earnest deposit within the time frame, right, which is three days, right, 3 calendar days or 3 business days? Then the seller can send a buyer notice to perform, right? And if the buyer doesn't perform, we still have an active escrow with an escrow number. We still need typically a cancellation sign. But every escrow officer and escrow company has their own policy and procedures. Some they say, well, we never had a deposit, so there's really no other alternative. We can just go ahead and cancel, right? But even having a open escrow without proper cancellation can open up a can of worms, because let's say that you put the property back on the market, open escrow with another buyer, close escrow or about to close, and that buyer originally says, I never canceled. Well, you never put any money in escrow, and more so we sent you the notice to perform. That's where you want to have the paper trail, right? Because if that happens, they can say that I never canceled. I thought I was in escrow, and I told you that I was going on vacation for 30 days and I would be back. They can come up with some ridiculous situation, right? So just be mindful of that. Partial release and reservation of rights, the most misunderstood section of the cancellation of contract is the cancellation in the transaction. Both parties agree to cancel the agreement and close escrow, reserve legal rights. Each party preserves all claims, defense, and legal rights. Hold deposit pending resolution. The deposit remains in escrow until claims resolve or release. Explanation: parties may cancel escrow while preserving all claims. The deposit does not need to be a deciding factor. Okay. In practical scenario, buyer alleged seller misrepresentation on solar system, both cancel, deposit held, rightful reserves, right? They can cancel, but there may still be a dispute regarding who's entitled to the deposit, right? So again, when these type of situations escalate, then I would encourage you to please bring it to our attention and let us help you navigate it. You know, sometimes it may take a while for the cancellation to be done, but I'd rather have the peace of mind that we have the cancellation and then now we can close the file officially, right? So final takeaway, contracts can end, escrow can close, disputes can survive, deposit can remain frozen. The cancellation form is not merely paperwork, it's a risk management. So with that, that concludes our class. Any questions? A lot of information, right? It's like, why did I get into real estate?
So if the buyer, send a contract to the, to its agent, and then goes home, and then a week later said, hey, my grandmother came to see me, and I was sleeping, I saw this dream, and my grandmother told me that don't buy this house. Is this a valid reason to cancel it? I wanna cancel it.
You don't have to have a valid reason to cancel.